Yeah, I was just going to give like a brief introduction. I really thank Tirza for this splendid framing of this event. We're really excited because having the experts in the field helping us understand and to frame some issues related to copyright and fair use is absolutely essential. In developing this event, we thought about using a problem-solving approach. That is, we are trying to look at specific issues and possible solutions to extremely complex and arbitrary phenomena. We actually began this process by asking ourselves and our experts questions like what are the appropriate standards of appropriation art, for example? What does it mean to borrow elements of existing works for purposes of criticism, commentary, parody of news reporting? How did the internet and digital age change our understanding of copyright and fair use? And also, who decides the rules of engagement? And we actually come from 2 points of view because also CCA is such an eclectic and diverse place. In this room, we have students and scholars who are mostly interested in doing research with materials that are often protected by copyright, and therefore there are like perceived or real fears about using materials that's protected. The most banal thing would be, for example, using a still from a movie in an essay about Derek Jarman, right? Do you really need to ask the permission to use that? Is that automatically covered by fair use? Yes, no. Is it better to ask, don't ask, don't tell? There are a lot of issues and consequences to all these acts. On the other end, there are also in this classroom artists that are using found objects for their art. What does it mean exactly to appropriate an element, a piece, a photograph, a video from an existing work? Is that automatically covered by fair use? What is fair use actually exactly? So these are just some of the issues that we need to untap and discuss today. So I don't want to take any more time because we have not one, not two, but three presenters that will basically dissect these issues from a variety of points of view. So without further ado, who's going to present first?
You want to talk? Yeah,
Lila.
I'll let Lila introduce. You want to introduce yourself a little bit?
Sure. I mean, we already had sort of a good framing of what's happening. My name is actually Lila. Really?
Lila.
Totally. It looks like when it's written, so I'm not offended by.
Well, my name is Teresa. It looks like I don't know what.
Yeah. So you feel
anything that starts with a T.
Yeah, you'll respond exactly. So
sorry.
It's fine. Don't worry at all. But so basically, what we wanted to do here today is, as Matteo said, hopefully actually demystify a lot of this whole, like, I heard words like arbitrary and mysterious and there are these perceptions that fair use is and copyright law is sort of this mysterious thing that happens in a back room somewhere that doesn't make any sense. And so what we're really hoping to do here is walk you through how a court thinks about the process of deciding whether something is fair use so that you can make that decision on your own without having to worry about lawyers. There are areas of fair use that are in the gray areas, but there are also areas that are pretty cut and dry, and actually many communities of people rely on fair use every single day. In fact, we all do. I mean, everything you do on the internet, you are relying on fair use, 100%. So it exists in our world, and so it's something that we really we're hoping to make less scary, less mysterious, and much more actually a friend to you. So that's what we're hoping to do here, and we're going to sort of jump back and forth, but we also really want to encourage you guys to just jump in. We want to have a conversation. If you have questions, please ask us as we're going on. This is for your benefit, not for ours. We already know this stuff, so if you have any questions, please just jump right in. So Julie's going to walk us through sort of an overview, and then we're going to get into the case studies.
Yeah, and so just to give you a little bit of background about my practice, I'm a lawyer and I run the Fair Use Project at Stanford Law School. So I do represent artists who are using copyrighted materials, incorporating them into new works. A lot of what I do is advising different types of artists, lots of filmmakers, documentary filmmakers in particular. I also, other scholars, artists, visual artists, helping them through the production process of, here's what I'm doing, here's what I want to do, can I do it, can I not? And so lots of times you need a lawyer's advice to know specifics. But there are general principles that you can know and understand that will get you, really far down the road. And so just to give you a sense of that this presentation is intended to provide you with those kind of general principles and understanding of fair use, what it is. Obviously we're not here to give you specific legal advice, but just, expect that you would be an expert, but this will help you understand the issues. Then you can identify what you need. Maybe you're doing something and you do need legal advice, that's another step, but we'll try to give you some really good principles that you can grasp, and then some other tools that you can use so it's not just go ask a lawyer, that's what you need to do. So, okay, so that's what we're doing. So I just wanted to start out by talking about why fair use is important. And the Supreme Court has made clear that fair use is an important First Amendment safeguard. When you think about copyright and what copyright does, it gives creators a monopoly over their creation and what they have done. So we do that in order to encourage creativity, in order to make sure that people are rewarded for their efforts. And all of you as artists and as scholars have believe in copyright and you understand its importance. But there are limits to copyright, and one of the most important fundamental limits is fair use, and that's the ability of other people to build off of and use copyrighted materials to express themselves. And so the First Amendment issue, the free speech issue as we see it, is that copyright, if it's taken to extremes, it can actually choke off free expression. It can be used as a tool of censorship if someone doesn't like what you're doing or what you're saying or what your message is. And so we have to, really understand both the need to protect, copyrighted, what we protect creativity, but also encourage that creativity. And if copyright isn't limited, it can, stifle the very creativity it's supposed to encourage. So, in the Copyright Act, fair use is part of the statute, and so the preamble to the fair use provisions specifically lays out certain types of uses that are, considered fair. And so these are not at all, this is not a limiting list, but it is the kind of things that are these are, the fundamental things that Congress and the courts have agreed on. So criticism, obviously, comment, news reporting, teaching, scholarship, research, these things. So, if you think about the most basic example of what is fair use, if you are writing a book review in the New York Times and you need to quote the book in order to criticize the author's, ability to make a, cogent argument or a sentence that makes sense, you would not be able to literally would not be able to quote that, because those sentences, even just as sentences, are copyrighted if it weren't for fair use. So, obviously when you're talking about comment, criticism, those are areas where you can clearly see, yeah, you have to be able to do that, because who's going to say, yeah, and you can quote my book in order to say how terrible I am at writing, no one's going to give you permission for that. And so, there's some really fundamental issues. So then, obviously, you get into more, but fair use covers much more than that. And so the statute lays out the 4 factors that, I'm not sure how many of you are familiar with these, but we'll talk about that. So the purpose and character of the use is the first factor. And this has become really the key to understanding what is and what isn't fair use. And when we talk about the purpose and character of the use, you're talking about for what reason are you using the copyrighted material in your new work? And are you doing something that is transformative? Is it adding meaning and message and value? Or are you basically using it for the same purpose as the original? Also considered under this first factor is whether a use is commercial or non-commercial, and that has We'll talk about that some more, and lots of people have ideas about, or there are certain, kind of misconceptions that if something is commercial, it is therefore not fair use if you're not, and those are not true. But courts do look at whether something is commercial or non-commercial. Obviously, research, scholarship, academic kind of work, when you can, understand the non-commercial value, that helps, but it is not a determining factor. But that comes in under, when courts look at what's the purpose and character of the use. And the other, so then the second factor is the nature of the original work. That means whatever work you're taking, is it something, if you think of things as copyrighted on a spectrum, like the most valuable, the things that we copyright that we think are the most valuable are, really creative, original works. So let's say like the Harry Potter novels or something that's, very creative. That's copyright protected. So is a news article. And a news article may be, further on the other end of the spectrum where it's lots of facts. You don't facts are not copyrightable. And so if it's not a lot of original work, it's, the nature of the work is more factual than creative, then courts are like, okay, you can, that weight, where it is on that spectrum will determine how it's weighed in the fair use analysis. The third factor, the amount and substantiality of the portion used. So that means how much of the original are you taking. So this is not looking at how much of your work, let's say you're making a video and 4 minutes of your work, your video is 4 minutes long and you're only using 30 seconds of something. Well, we're talking about how much of the original are you using. So if you're using 30 seconds of something that itself was only 30 seconds, you've used 100% of it, even though it's only a small percentage of your work. So you're looking at how much of the original are you using. And this factor, I actually think, is going to become more and more important, and particularly in visual arts context, and we can talk about that in the examples we're going to talk about. But it ties very closely to why you are using it. So if you can justify, you have a rational reason and an explanation for why you're using what you want to be using, how much of it has to relate, it has to be reasonable in relation to your purpose. So those two factors tie together really closely. So a lot of the time that I spend advising people, we think about, okay, I get it, I understand, this makes sense to use this clip in your documentary. Why does it have to be this long or that long? Sometimes it needs to be longer to get or more of the original to get your point across or to make it clear. But those two factors really tie closely to each other. And the last factor is the effect of the use on the potential market or the value for the original. So the more that you are doing something that the purpose of what you're doing is new and different, then you can, oftentimes you also are arguing that this is not a substitute for the original, so it's not going to affect the market. No one's going to buy or go see my documentary so that they can see a 2-second clip of this major motion picture. Like they're not, one is not substituting for the other. The market harm is an important factor that courts look to, because obviously copyright is intended to protect people so that they can make money and market their works. If what you are doing, impedes that market, that is going to weigh against you in a fair use analysis. So the other thing about the market effect that becomes really tricky is that we have this whole breadth of what are called derivative works. So if you write a book, and a derivative work is a movie of that book. So if you're the author of the book, you control the rights to derivative works. And so what is and what isn't a derivative work is really at tension, and I think you'll see that in the cases that we talk about. Like courts can look at, well, you may not substitute for buying the book, but you would substitute for some other derivative market that the original copyright holder owns. You can be in trouble there. Okay, so obviously fair use can be, it can be daunting, but it's flexible. It's very fact specific. That doesn't mean that it's undefined or unreliable or that no one can really rely on it. I advise people all the time. Lots of people are putting it to use and making, getting their creativity out and being productive and able to rely on fair use. But it is ultimately just a risk analysis. There hardly any time that I could say to someone, every judge and every court, if you were sued, would agree that this is a fair use. Sometimes there are some examples, but very rarely. So it's not bulletproof. There's no, there's always, it's something that does, like, because it's fact specific, it does, get litigated. So the idea is, what can you do to put yourself in the strongest position possible, so that if somebody was upset about what you were doing, they either aren't going to sue you because it's a risk for them too. So, that's the benefit of it being, kind of a risk, is that, you can't just think of it as like, oh, I'm going to get sued. Frankly, people can sue you for anything. I mean, there's some really ridiculous examples of, like, I don't know if you guys heard about the Woody Allen film where he was sued because one of the characters quoted Faulkner that was part of the script. And he said, oh, that's a quote. The character in the movie says, Faulkner said that. And the Faulkner estate sued the, Woody Allen and the major motion picture studios for copyright infringement, which is just absurd. I mean, it was dismissed at a motion to dismiss stage, but the fact is, you were in the world, you can be sued. So there's that kind of risk. But there are other things where, you can put yourself, in a very more strong, defensible position where, you can mitigate the risks as much as possible, but ultimately it's how much risk are you willing to take that, really comes down to it. And I just quickly want to say that, the flexibility makes it, sometimes you're like, just tell me how many seconds can I use, what size of a picture can I do, just give me a rule. That's great for, one-off kind of situations, maybe, but it's horrible when you think about, things are being invented, innovation is coming up all the time that relies on fair use that, thank goodness it's flexible, because then we have all of these new tools and different ways, that people can use it, and we don't want it just be strictly delineated to a few things. So those, the flexibility is really important, particularly for innovation in the art space, innovation in technology, all of those places. But it is, like I said, fact specific. So that's where we're going to get into some examples in a minute as I stop going on. But okay, so transformation is the key. Out of the case law of the last, I'd say, 20 years, really what courts are focusing on is, what are you doing? Are you doing something, like I said, with new meaning, new message, something that adds value for society, it has a benefit. So, if that is new expression, that is much more likely going to be, something that courts can say, okay, we understand why you're doing this and why we shouldn't stop you from doing this. Or if what you're doing is superseding the purpose of the original work, then you're going to be in trouble. They're going to say, this is the same thing, you're just, changing it from black and white to color or something, maybe that's not right. So we're going to talk about some examples that have been litigated. We're focusing particularly here on cases where images are involved. And Lila's going to start here with talking about this case.
Okay, so we've heard a lot about transformation, but how do you actually apply that, right? That can sound really, really vague. Well, one of the classic examples of transformation is a parody. For many, many, many years, way before even this recent trend towards transformativeness, courts have held that making fun of something in an obvious way is generally not something you're going to be able to get permission to do, but it is something that we as society want you to be able to do. So being able to create a parody is something that fair use has always favored. So what we're going to do is actually walk through, it's a little, you can't quite see the images here, how different they are and how similar they are, but we're actually going to look at these examples and sort of see what pieces are the same and what pieces are different, and how the court looked at that to determine whether or not this is a fair use. Does anybody know, by any chance, whether or not this Naked Gun poster was held to be fair use or not? Anybody just know this case by any chance? Okay.
What would you
guess? Hazard a guess?
I would say yes.
You would say yes? Fair use?
I think that it looks like her body, so I mean, it doesn't look like it, so I'm guessing no.
You're guessing no? Okay.
Well, who sued? The photographer or the magazine?
So the Vanity Fair photographer, Annie Leibovitz, sued Paramount Pictures for the movie poster. So the answer is, it is fair use. And so, so what the court looked at first was this question of what is the purpose and character of the use? Well, it's the most commercial use you can possibly imagine, right? It is literally an ad for a movie. Okay, so we're in the most commercial context you can possibly be in, and yet at the end of the analysis, the court still found this is fair use. So I think this is a really good example that sort of pushes back on this idea that you can never make commercial uses and have them be fair. So the original photograph is this sort of very serious take on, you know, the beauty of the pregnant woman's body. It's, you know, her face is obviously very sublime, and it recalls Botticelli's Birth of Venus. There's all this discussion about this image as being very sort of evocative of femininity, and it's rather serious. It takes itself very seriously, right? We can see this. Now, the differences we see in the next photo, so this is not actually Leslie Nielsen's head just photoshopped on top of Demi Moore's body. They actually did a new photo shoot. There's actually, again, it's a little hard to see here, but the lighting is actually quite different. In the second photograph, the lighting is much harsher, it's more garish. You can see the ring on his finger is much blingier. And I think the biggest thing is the expression, the facial expression, right? He has this smirk that seems to be making this commentary on the sublime seriousness of the original. So something that you might wonder is sort of like, well, how does a court decide whether something's a good, like, do they think, is it a good parody? Is it funny? You know, like, does it have to be a funny parody, for example, in order to be held to be a parody or be fair use? And the answer is no. So what the courts actually, all they look at is whether or not you can tell this is a parody, if the parodic character is apparent. That's how courts talk. So basically, the court looked at these differences and said, you can tell that this poster is really just making a commentary. It's mocking, it's smirking at the seriousness of the original work. So it's not merely that the ad was different from the original, it was that you could tell that the ad is trying to comment on the original. You can sort of see that there's a relationship between the two. So this is a pretty classic case of fair use. When the court looked at the question of, so how much did you take and was it reasonable in light of what you're trying to do here? Well, with a parody, it's actually quite important that you be able to take enough of the original work so that people understand the reference that you're making, but not so much that it just looks like you're substituting for the original. So it's a bit of a fine line here, but the court held that, yeah, they took quite a bit of the original, but that's fine, because it was reasonable in relationship to the commentary that they were making. And again, you know, Annie Leibovitz, who's a photographer here, did have licensing revenues, but again, because this is a parody and it's something that's making fun of her work, the courts are pretty they understand that it's very unlikely for a licensing market to develop it for parodies, so the court said there's no market harm here. So in walking through all of the factors, the court found on the whole, this is transformative, there's a new message and meaning being added here, and we're going to say that this is fair use. Okay, so the next case is a Coons case. So you guys probably know that Coons has been sued more than once. And I'm going to first talk to you about this case, and then I'm going to go back and talk to you about an earlier case of his. So this case is also about transformativeness, but it's not a case of a parody. This is, so what we have here is the original photograph is an ad for these Gucci silk sandals that was done for Allure magazine. And the Jeff Koons piece, he has now taken this ad, put it into this context of landscape and food, and his rationale for what, sort of what his message is here is to sort of divorce the viewer from their usual understanding of appetites. This is the way he described his, and so her purpose is selling you sexy sandals. His purpose is to disrupt your idea of sort of mediated images and how mass media communicates to us about our desires. So the question here you could ask is, well, why use these, right? Why this particular picture of feet, right? Some, in the past, courts have been particularly concerned about, like, well, you didn't have to use these feet. But in this case, basically, what Koons argued was, these feet are so typical of the way that mass media talks to us that I needed to use something that looks like something that we've all seen before in magazine ads. So I needed to use a magazine ad, and I used this magazine ad. And the court said that this was transformative, even though it was not a direct commentary on this specific ad. And the reason is that it was basically using this copyrighted work as the raw material for commentary about society more generally. So he's adding a new message and meaning to sexy Gucci sandals that's basically like, hey, why don't you think about it in this other way? And the court said, okay, we buy that. We believe that you have this artistic rationale for using these particular feet. Now, the court specifically did say he's lucky he had that rationale, because if it was just a matter of saying, I took a photograph and made it into a painting, that wouldn't have sufficed to be transformative enough. It was really this new message, this artistic rationale and purpose that convinced the court that this was transformative. And again, this was in a commercial context. This was commissioned by Deutsche Bank and the Guggenheim Museum. He had made some money off of the exhibit, and the painting had been valued at $1 million. It hadn't actually been sold, but there was sort of this sense that this was a commercial use. But again, there was no harm to her licensing market. She wasn't going to be going around selling people licenses for this sort of thing. And so the court said, this is fair use. So, yes?
I'm going to be your shell for
Please.
this. So so this seems like a stupid question to me, because it seems like it's obvious to everyone. But so are the Gucci sandals actually like the second from the left?
Yeah. So
and it's not really.
So there are these that have been flipped around and put here. So
there's
these.
So he literally.
See, he cut them out.
I see.
He cut them out, flipped them around, and
Okay.
they're here.
He literally scanned it.
Got it.
wasn't
Got it.
actually a
Got
copy.
it.
So what's the date on the diagram? Is it Photoshop or is it old advertising, clip, cut, and paste?
That's a good. I believe it's a painting that's been done. It wasn't photoshopped.
Yeah.
It's 98 or something. So this is
Right. It was. I don't know exactly how
his assistants did it.
technique, but the evidence was that it was
Plausible
a
deniability.
scanned image. It was an act. It was literally a copy. And so obviously he's painted it, or however they add the color, or whatever his techniques are.
But see, that's interesting that it being a copy, the court disregarded the fact that it was a direct copy.
Yeah.
Like you said, a painting of that, which would be a much more drastic transformation.
You would think in sort of the artistic sense, but in terms of this messaging.
In terms of like the physical, you
Right,
mean
the
like
physical
in a
manipulation.
physical manipulation kind of way that
If
one person is
somebody
drawn.
translated a photograph into a painting,
Yeah.
which happens
Yeah.
Yes.
all the time.
Which
That
also
would not
could be just as much as a copyright as sticking it in a copyright infringement as sticking it into a Xerox machine and making a copy. It's depending on what your meaning and message and added value is.
Right. So this is what Julie was talking about with derivative works. Right, so that translation that you're talking about would probably constitute a derivative work, right? So I, as the photographer, would have every right to make a painting out of my photograph. That would be within my, or commission it, or license somebody else to do that. That would be well within my sort of core rights as a copyright holder to do that. So the question is, when somebody else comes in, what are they adding to that I wouldn't say, right, as the original artist? But, you know, what is this new message or meaning that's being added that the original creator didn't come up with? Thank you, Matteo. And, you know, I think one of the other pieces of this that's interesting to note is that the court, I think the fact that it was literally a copy actually helped him, because his argument was, I need a certain amount of authenticity here. If I had done my own photo shoot, for example, I might not have been able to faithfully represent the way mass media communicates with us in the same way as using a real actual ad. So the fact that this ad gave a layer of authenticity or veracity to that messaging was part of the court's analysis. So, you know, this idea of transformation is a transformation of message and meaning more than it is sort of a physical manipulation question.
And I would say, and looking at the prior example where they didn't actually copy, you know, Annie Leibowitz's photo,
right,
and they made their own, I would argue, maybe you guys disagree, but like they could have just taken the same photo and superimposed, you know, his face, or, you know, added effects to it, instead of like recreating their own photo shoot. So even there, it's like recreating the photo shoot and intentionally making it as much of a copy as the original still could be copyright infringement. And the reverse, I think, is also true, that if they had decided, like, well, we're not going to go through the trouble of actually reshooting a whole photo to make it look like that, we'll just Photoshop or do what they can do. If the ultimate product ends up with enough obvious parody, then maybe it could have been. Obviously, the things that they did that the court commented, the lighting, the ring being different, that kind of stuff was part of the fact that there was a whole separate photo shoot. But there probably were ways that they could have done that same thing through Photoshop or using the same photo. And so you can see where like the literal copying is not the determining factor.
Yeah. So I'm going to go back and mention this older Rogers v. Coons case, because you may know that he had been sued over this. This case happened in 1992. There was a very big Supreme Court case that happened in 1996 that has now moved jurisprudence towards this transformative use standard. The reason he lost this case has more to do with when this case went to court than anything he did differently as between these two cases. So unfortunately, perhaps, you know, people in the real world are sort of subject to the fact that jurisprudence does change over time. I think we're headed in a good direction for art and innovation towards this transformativeness standard. But here, if we look at the standard that we have today for transformativeness, I think there's a very good chance. I mean, he lost this case. He had created, this was a photograph that he found on a postcard. He created a series of sculptures out of it. The court said, oh, you're not really commenting on the original enough. They didn't like this before the transformative, sorry.
I was just going to say there were some bad facts there too, because he was instructing his people who were making this sculpture to make it as much like the photograph as possible. I think that, you know, the court's kind of like, you know, like getting back to this, like literally copying it, like why is this something we need to protect? I also would just add that, like, I know from people who have seen this actual sculpture, you know, like one of the problems that happens when you get these cases in court is that the court is looking at these two pictures side by side, which is very different than being in the room with the sculpture versus this photograph. And understanding, like, maybe he does have a really
Could they not bring this in as evidence?
I don't know that they couldn't, it just didn't happen. That's just not the way it was evaluated.
Because usually these are not happening at trial where you physically bring something in front of a judge, you submit it on paper, and so you have to, usually these things are litigated on paper. And I think,
yeah, and I think just as artists and lawyers who work with artists, like that's one thing that's really to understand, you know, it's like I've represented artists where their works are like 17 by 10, you know, and they're you know, using something that's very small, you know, to do that, and so like to get a judge to understand it, you want to, you know, try to think of those strategies of like, hey, no, the actual real thing is more important than trying to represent it on paper. And so there are ways, you know, to deal with that in courts too. But it's just
so, how did the Kunz's reproduction affect the market value of the? It seems like it would.
This is just one of those honestly ridiculous. There was no licensing lawyer for this photograph.
The idea was that if it's not transformative enough, if it's not something new and different, then it is something where you want to use this photo, go ask them and pay them a license and use their photo and turn it into a sculpture. I mean, that was kind of the court's perspective.
That's the commercial aspect that the
commercial
photographer
So he was making a lot of money off of these sculptures. These sculptures were being sold for like $400,000 or something in the 90s, right? So he was making a lot of money, and the court saw that at the time. Again, like they cared a little bit more about commercial than we do today. So the court just didn't like that he was making all of this money off of somebody else's work. And the title of the show was something like The Banality. It was like a show about banality. So it was like very much saying, this is a banal piece of crap, and I am making this awesome sculpture that I'm going to pay, that you're going to pay me $400,000 for. And I just think the court, based on the former way that the courts looked at this, like the court just didn't feel good to them to say that's okay. Today,
I think one of the quotes that came out of that case was like, well, where's the line? If he can do this, then why should anybody ever pay a license to this photographer to do whatever they want with this? This is just, he's using it as his raw material. I think, like Lila is saying, we have the shift in the understanding in courts and the idea that transformative, maybe if he knew that's what the standard was, he could have created, he could have articulated his creative rationale the way he did years later in the Blanche case, so that they could understand what his message was. That his message was, because if you think about it as
this is direct parody,
or criticism of this,
if I were arguing this case even back then, I would have called this a parody. I think the lawyers messed up on this one, honestly, but anyway, so.
Could I ask you to explain that last to your justification, why you think they've messed up?
So the context, the show was called the banality of everyday items or something, right? It's literally commenting on, this is banal, this is not creative, or what, and I think there isn't a licensing market. If you said, hi, Art Rogers, I would like to take your photograph and then make it into a sculpture that is about the fact that your work sucks and is banal and lame, and that I am judging your work. And do you really think Art Rogers would have given this man a license? I think the answer is probably no.
So even if it's not a parody, maybe it's criticism or just commentary or whatever, that's.
But Kunz loses, right?
He lost this case, but again, we think, in our opinion, if these same facts went to court today, it would probably come out differently.
Wow. What was the judgment then? Did he pay for
it?
Did he pay for it or destroy it?
He had to destroy it.
He actually gave them, I think he gave them the sculpture.
He gave them 4, I think, 3 or 4.
He had sold 3, so he had to give the money for the 3 over, and then he either had to destroy or give them the sculpture. And I don't remember what happened with the 4th sculpture, whether it was in fact destroyed or whether it was given to the other artist.
So, and you're probably going to get to this, you sort of alluded to it. Part of what's going on, I think, here is a sort of discussion of modernism and postmodernism in a way, and it really, I think, weighs heavy on the recent Prince decision. And who's bought into these kind of ideas that pretty much everybody in this room has kind of drunk the Kool-Aid around it, including me. It's like, we can do this kind of critique because it's been going on in Western art history for, several centuries. So Picasso does Manet's Olympia and everybody else follows and follows and follows. But there's a whole bunch of people who are not really invested in those ideas. They don't really.
No, it's true. And
including the judge for this case. Because to me, her decision says, I don't buy modernism, I don't get it, it's not persuasive.
Yeah, because you have, this tension, which is the idea that as a photographer, particularly I feel like photographers are, kind of embattled in this space of like, how do I make money? And you know, you have this tension of people who have an idea of like, I've copyrighted something. Anything that uses my thing or takes from it is something that I should be able to license or make money from, particularly if it's being used to make millions of dollars for someone else. And so, you know, that tension of like, oh, you know, now, you know, you have these artists, Jeff Koons, Richard Prince, you know, but they do fall in a long, you know, Sherry Levine, you've got like a long line of artists who are using, you know, existing work and appropriating images and that kind of stuff, you know, and so it's like, okay, what do we do with that, you know, the tension between creative people, and where does their rights that they have in the original works that they've created, and obviously they have a copyright, where does that stop and the other person's rights begin? And it is really hard. And I think, you know, the Cario case, so the Richard Prince case, I guess, are you all familiar with this case? With Richard Prince. Okay, so Richard Prince is a artist, visual artist, who is also a you know, well-known appropriation artist. He's, you know, some of his most famous paintings were like the Marlboro Man ads, where he took the Marlboro, why is that word so hard to say? Ads, and, you know, made them into, you know, paintings that was literally, you know, a copy blown up, you know, of these things. And the case, the Cario versus Prince case, involves photographs that Patrick Cario took, and he's a professional photographer. He spent, I think, 7 years in Jamaica photographing Rastafarians for his book called Yes, Rasta. And so his point was, you know, he was celebrating the Rastafarians and depicting them very respectfully in their actual environment. That's what he was doing. He was documenting their lives in this book. So this is an example of one of his photographs there. Yeah. And then Richard Prince, you know, so he's this appropriation artist. He decided to make a series of paintings called the Canal Zone, and it's a series of 30 paintings. This is one of them, the other side of the island. And you can see there in the center the Rastafarian from the prior photograph. Right here. So this is one of 30 photographs, or I'm sorry, one of 30 paintings that he made. And so he has, in the various paintings, he has collaged, enlarged, cropped, tinted. He painted over, you know, 35 different photographs that he took from the book Yes, Rasta. And so, you know, Richard Prince is just going, this is what he does. He's going through books, he's like being inspired by this imagery. You know, he literally is like ripping out pages from a copy of this book that he owns or he bought or whatever. And so some of the paintings used a substantial amount of those images from the photographs. This one is an example where it's less. There are some where you can't even detect, like from the naked eye, you wouldn't really be able to detect what in that painting is from the photographs. But so his you know, Prince, unlike Jeff Koons, did not come up with a, you know, creative artistic rationale with, you know, like what, you know, when they asked him what his meaning was, he, you know, he's an artist. He doesn't want, he's not going to tell you what he thinks you should think it means. You know, he explained what he was doing with his paint, with the Canal Zone series, which was, you know, he was depicting this post-apocalyptic world, and he had this whole story, and there was this whole thing, you know, and he's transporting these Rastafarians into this like foreign realm, and it's very garish, and he uses the imagery and obviously the naked women, other, you know, he's collaging it with lots of other things, so it makes it very distinct and different, obviously, than the photographs, but the photographs, parts of the photographs are appearing in his paintings. So he is, you know, to me, it seems fairly obvious that this painting has a different meaning than this photograph. Different message. They're conveying totally different things. I can't particularly, even if I can't say what that is, what Richard Prince's, the meaning of that is, I can say that it's very different expression than the original. And so what happened here was that the district court, so at the trial court level, the district court judge, kind of like what we were just saying with Jeff Koons, where she just was like, nope, I'm not buying it. Like this does not comment on or criticize his photographs. There's no reason why he's using these photographs, unlike Jeff Koons, who could at least articulate, even if he wasn't criticizing or commenting on Andrea Blanche and her photography skills or the way that photo was taken, he was using it as an example to comment on bigger issues. Here, Richard Prince, he's, just saying, no, these are photographs that inspired me to do this and I wanted to take it. He's just using them as raw material, basically. And so at the district court level, she said, no, you don't comment or criticize, you're not using it as a parody, that's therefore not transformative. It's very much commercial enterprise. Prince is making millions of dollars off of his works. There was some evidence that, which is a little sketchy, and you probably, if you've read about the case, heard about that Patrick Carriou had an art show that was supposed to be a display of his photographs that was canceled because they found out around the corner Richard Prince was having his show and whatever. It's unclear whether that really was a cause and effect, but that can affect them. That's like, obviously I was harmed. I was going to have this show and now I'm not because this guy took my photos without asking me or paying me or anything. So one of the keys, so then when the case was appealed, so Prince lost. Okay, so here's the real rub of why this is so dangerous, of saying, no, you can't do that. It's not just pay him. He has the right to decide what's going to happen with your painting. There's an injunction. The district court issued an injunction in this case that allowed that called for the destruction of the work, which is just outrageous in a free society. We don't burn books. We don't burn paintings. You don't take art off the wall. Like, what is the damage here to Patrick Carriou? The problem with asserting copyrights, in this way and having, if copyright is to prevail, it can literally silence or destroy work that exists and obviously is valuable. People are finding value and meaning and appreciate this stuff. They're buying it, they want it, and now a court's going to come in and say all of that stuff has to be destroyed. That's pretty alarming. So when the case was appealed and this injunction was appealed, the arguments were, Patrick Carriou was saying, look, Richard Prince doesn't even say why he just took these photos. He has no reason for using it. He just liked it and he did it. Whereas Richard Prince maybe he's not the most articulate or he's not the best coached by his lawyers to say the precise words. And so I actually represented the Andy Warhol Foundation. We did an amicus brief at the Second Circuit. One of the things that we argued was that courts should not rely on what the artist, it shouldn't come down to whether the artist can articulate a specific rationale for using what they want. In my opinion, it's like, well, yeah, what happens if that person was dead? Then you couldn't defend their work because they couldn't sit there and tell you what it meant. Or let's say, they just aren't, they are artists. They are not people of words. They're using visual, arts to express themselves, not, legal terms or something that satisfies what a judge would think. So there's lots of problems with relying on the artist's ability to articulate it sufficiently to a judge. So the court actually agreed with that, which I think was a huge step forward in evaluating what's transformative. And they're like, what does the reasonable observer see? And whether a reasonable observer could perceive new meaning and new message in there.
Which is the same standard for evaluating a parody, right?
Yeah.
So why should it be a different standard when
Right.
we're looking at visual art versus a silly ad?
Yeah.
Right? So we have the same standard now, which is as a
And I think it gets back to what your point is that people, maybe people understand jokes. They understand why when you're poking fun of something, you have to actually use it to, it's something that's in our culture and we've been doing a long time, and so it's hard for courts to say, no, you can't do that. But with the visual art, in the past when it was happening, it maybe wasn't challenged. Now it's being challenged, and they don't understand why this technique is so important.
Right, well, that's the technique, because I think it's a broader question about what is art, what is good art, and what is, modern art, right, we'll all say, says it's the idea, and postmodern art will say it's the idea.
Yeah.
And people both look at Prince's work and say, what work have you done and why is it good? It's not evident to me if realism and naturalism are my standards
Right.
for accomplishment, thing one. And thing two, it's the truth of photography that still reigns.
Right.
So Carrio's work is, I mean, I think you documented it as documentary, but to me it's different from a news photograph.
Yes.
I mean, and he's actually trying to bridge that divide between something that is news-like, black and white photography, and something that is going to make into the realm of fine art photography. He's
Yeah.
trying to move from, you know, I don't know, Dorothea Lange to Sebastian Salgado, in a way. So you know, he's making a move too.
Yes.
That I think is part of this whole discussion.
Right. And part of the thing with what Patrick Carrio, as far as like the market effect, you know, like looking at Patrick Carrio was able to make, you know, he made his book, he intended, you know, he did this photography so that he could make a book, he did publish it. Richard Prince's artwork has no impact on the sale of Yes Rasta, or this collection of photographs. In fact, if it has an effect, it might be a positive one, because, you know, more people know who Patrick Carrio is now than ever before. But yeah, so like the question is, but is it a derivative market? Is it something that Patrick Carrio should be able to control, to say, if you're going to use my stuff, even if it's in this art, you know, in this new way, you should come to me first and pay me a license and get my permission. So, but to remember, it's not just money, it's permission. It's, can you get him to agree that you're allowed to do what you want to do?
To what extent is a lot of this driven by just the fact that the stakes have risen so high in terms of commercial value,
Yeah.
that make it both really valuable for an artist like Richard Prince to use material and that he wants, and also really valuable for Carrio to challenge that use that didn't exist in the 19th century in the same way, or even the early 20th century. And certainly not before that, where value, you know, where art was created under different conditions, and also just the fact that we have, you know, a different kind of litigiousness within society. Like,
yeah, I mean, it's such a hard problem because, I mean, so much of what we talk about is who gets paid.
Right.
And if nobody's making any money, we're not arguing, right?
Yeah.
So we
or
have,
people just feel ripped off.
yeah.
Or not ripped, or, I mean, like there is a lot of perceived harm in the world that doesn't get litigated because there isn't value, but there's a whole emotional context to this. I'm sorry if that's what you're
That's
getting
exactly
to.
right.
Yeah.
We're weighing it on both qualitative and quantitative metrics, and that's you know, really hard to do at the same time.
Yeah, it is very hard. I think you're right. You know, there's definitely the idea of like, you know, there's money to be fought over. I mean, I would argue the value that Richard Prince is getting for his paintings. This is like an impossible thing, but this is the kind of stuff you have to start thinking about. Is like how much of that value is driven by Patrick Carrio's work, you know, and how much of it is, you know, or how much of, you know, Picasso's, you know, appropriation art is valuable because it was Picasso doing something to it, or whether it was based on whatever he was, the found objects or whatever imagery he was using and incorporating into his work. You know, it's really, this is like really, I think, at the edge of like what is the most difficult about, you know, fair use and, you know, what it, you know, right now. And so even in the Richard Prince case, there the appellate court held 25 of those paintings are fair use. Done. He wins on 25. 5, the court remanded back to the trial court and said, you know what, on these 5 we can't really tell, and I didn't use slides to show you which 5, but those were more where it was much more of the photo was being used. This kind of gets at what I was talking about, like the third factor, how much are you using, I think, is one hook that courts can be like, on some kind of quantitative scale, be like, how do you draw this line? Well, we'll draw it at, you know, you took too much of that photo, even though it has a totally different message. In my mind, the splitting of 25 and 5 paintings makes no sense, because 30 paintings are part of a series. They all have this different message and meaning. They're part of a bigger thing. They aren't individual. But when you try to, you get into like, a legal realm or something where you're trying to draw these lines and make these decisions, you look at those 5, and honestly, if you walked into my office and you gave me one of Richard Prince's paintings, one of the 5 that was remanded, where they do look very similar to the photograph, I before this case was decided, I'd probably say, yeah, that's going to be a hard one to win. When you mix it in with lots of other ones where they're much more of an argument of like, you've added lots of original, your own original expression, you have this whole different thing, it becomes easier, I think, to say, like, yes, I understand why Richard Prince is very different than Patrick Carriou, and he can do it, and Carriou is not negatively affected in a way that we care a lot about, because he is still allowed to get the value of his original. So it's interesting. So that's still being litigated at the district court level, and it is a question of, okay, so if we talk about whether reasonable observers can perceive a difference and meaning and message, who are those people? Are they art critics? Are they, the curators of museums? Are they the jury of lay people? Would, just the common person on the street understand the difference?
Yeah, can I just shift the arena of, just shift the focus to how these cases and how case law affects us as scholars and in our as teachers, in the classroom, that kind of thing, but also in terms of what how fair use, what the implications of this case law are for those of us who spend years acquiring permissions and paying for permissions to reproduce images, or sometimes exclude them on the basis of seemingly arbitrary denials by copyright errors.
Yeah, and you mean by either teaching or writing?
I actually mean by publishing,
yeah,
in particular.
Yeah.
Like, it comes up every year, even in the VCS journal, which is student work drawn out of their thesis. It comes up about the thesis, which we, have in the library, and we publish parts of that online. It's not it's not password protected. And these questions are like constantly plaguing us as scholars as well as artists. And I'm just wondering if we could throw that into the mix.
Yep. So we do have, we can skip to that. There aren't cases about that. I mean, that particular use has not been heavily litigated, which kind of tells you something. What it tells you, you might know better than me, because this is your world and your community, but I think in the scholarly world, there's a lot of norms. And a lot of those norms are around getting permissions, it's risk aversion, there are these powerful copyright holders who have more bargaining power than your so your average scholar has much less bargaining power than the big journal that they want to publish in, for example, or say it's the Getty or some other big copyright holder that owns many images. They are often just able to dictate terms because what we've been talking about a lot here is kind of this question of like, well, there are certain things that end up in court, but there are lots and lots and lots and lots and lots and lots of things that never see court. That is because there are norms, and it is because either institutions are not willing to go to court about it, they'd rather not have the fight, not because they think that they would lose, but because there's sort of relationships in the field, perhaps, right? So there are a lot of sort of just historical reasons why sort of like universities have paid licensing fees for things that they honestly don't have to. It's a similar thing in the music space, actually, with sampling. The record companies just decided we're going to pay each other for samples, even though, honestly, if people had fought it out under the standards of fair use, there's some good arguments to be made that sampling is probably fair use.
Similar to
But
what
we don't
Richard
have the
Bruce
case, yeah, we don't have the case law on it because of the norms that have developed in these communities around when permission is asked and when permission, yeah.
That's interinstitutionally true, but most contracts for scholar's indemnify the scholar. It's that's the way things are written. It's our responsibility. It all comes down to us.
I would say a part of the problem, and I've seen this a lot with scholarship in particular, is there is a, for whatever reason, maybe it's because photographers or imagery is like feels like an invalid space where they do have to fight about all this. It's taken things that don't make distinctions that don't make sense. So obviously historians, when they write, they quote lots of stuff. That's what makes them believable, makes them, look like they actually did their research, they footnote it, they don't pay license fees for quoting sentences. When you're doing an article, an academic article, and you use an image to support your argument, then people, publishers in particular I've seen, freak out. Like, oh, no, you have to get permission to reprint that photo. Right? Why? What difference is it as far as like a legal argument of why you're using that to support what your research says or whatever? And honestly, I do think it is norms. It's the idea that images are somehow different. I've had law professors who write. I've had one that was writing an article about using imagery and why images are necessary, whatever. And she was publishing in a law journal, and they were pushing back against her for using the imagery. It was just like she just had to take a stand of, no, this is fair use. This is something I'm allowed to. We helped her with that, but you really, it's kind of a muscle you just have to exercise in a lot of. And I'm not saying that scholars just back down, and that's why it's a problem. There's lots of chokehold points that publishers will just flat out refuse to publish, or
even
whatever.
though they're holding the scholar responsible, they won't publish.
Yeah, because the scholar's quote unquote responsible, but if you don't have money, the publisher knows that your indemnity means very little to them if they get sued. That's their worry. And to them, they're like, I don't care about the principle, I care about whether we can continue as a business or not. So there's that problem, but I think there is a bit of, because documentary filmmakers went through this as well, which is like, people saying like, no, you can't use anything that's unlicensed in your films or you'll never see the light of day, and they really have developed more as a community, pushing back against that, actually doing it, exercising their fair use rights, and developing more norms that are, this is okay, insurance companies cover it, the uses, and so that gives the filmmakers themselves some reassurance and risk avoidance because they have an insurance policy rather than their house on the line. And so maybe there's room for that. I think, for academics or for, people who are using that, because it is a problem. And I talked to somebody who was doing, people were like, I want to do a dissertation. I've worked 5 years on this particular artist. Now I have my thesis and I cannot publish it because that estate will not clear the rights to the images I have to use in order to show my thing, And so it's like, what are you supposed to do?
When they publish the online, it's all black squares, right?
Yeah, because the online rights are different than what's they've licensed in print. So there's all kinds of problems, and I think this kind of, from my perspective, gets into why licensing can be really dangerous. When you give in to like, okay, fine, you want a license, I'll just give you a license. I'll pay, do this thing, and then it's like, when that breaks down, you're in a really hard point. Whereas if you had relied on the idea that you didn't need a license in the first place, you might be stronger. You know what I mean?
Yeah.
So it's a challenge for sure.
Yeah. So we have we can decide so we have a couple of other cases. Matteo had asked about this case in particular, but there are other cases that are a little bit more relevant to your sort of question about academic uses. And then we have a whole section on best practices guides that have been created by communities. And that does get into these sort of more like academic uses and questions like that, or we can just kind of continue to like.
Well, we have about 40 minutes left, so just looking at who's in the room, I would say like anything that's relevant to our academic lives
Yeah.
All right.
would
I think that
Yeah,
was
why-
warrant
yeah,
that
what
kind of
do you-
emphasis, yeah.
Okay.
I'm okay. So this is some of the visual art cases that we've been talking about had more to do with transforming the meaning or the message of the original work in the new work. And this is a case that's using transformation to talk about using the work for a different purpose. And this will lead into some of the academic conversations. So this is a case, it's a book by DK, and it's called The Illustrated Trip. It's a 500-page coffee table book that chronicles the Grateful Dead. The book has about 2,000 images of it in it. It's set, the whole thing is built around a timeline of the Grateful Dead. Most of the images are set against this timeline. You can see that it's all collaged together, images, text. In the course of building this book, DK sought permission to use 7 Grateful Dead concert posters. Bill Graham Archives held the rights to those posters. They were in the midst of negotiations to use these, and the negotiations broke down. DK went ahead and used the images anyway in the book. So the book has these 7 concert posters. They're the entire image. They're obviously a reduced size, but they're the entire image reproduced in this book. So the court looked at this, and it really looked at the purpose for those objects. The purpose of the original concert posters was to promote an event. And it found that the use here in the book of using them as historical artifacts to document the history of the Grateful Dead was a transformative purpose. The purpose was entirely different. You know, the court really did emphasize that it was set along this timeline. It was contextualized. The text was added, but it found that this use was a fair use.
Wasn't it like also it was fair use because of the size? Wasn't that also a key element, like, of this particular case of the Grateful Dead?
That it was a reduced size.
Yeah, I remember
yeah,
the size being an
The
issue.
thumbnail image.
It was a
Thumbnail. It's a thumbnail thing, right? Which is interesting for us because there's some images that we cannot thumbnail,
Right.
right? And that's kind of where we get to the scholarly part. It's like, well, a thumbnail isn't going to work in the same way that it did
Yeah.
in this
Yeah.
publication.
Right.
I wouldn't say
Yeah,
it
there's a-
turned on that,
it
but
didn't.
it was a very helpful fact.
Yeah.
If you made a coffee table book and you reproduced the entire poster, maybe say this whole page, one whole
As a whole
page
page.
or something, then and you say, oh, maybe you are taking it, you know, you are, because here the point was, if the original was like an artistic poster that also advertised an event, the thumbnail, you know, by reducing the size, you're obviously not just trading off of, look at this beautiful picture,
Right.
you know, you're using it as,
Right.
you know, that your purpose becomes more clear. And so
Yeah.
it's like tying how much of it to the purpose.
So I thought, like, sorry, I'm coming late, but I've been
That's
involved in copyright litigation lately. And I think it was also this idea that, you know, you couldn't necessarily displace the value of the original by thumbnailing it, right? Whereas if you put it in it at a bigger size, it would displace or somehow impact the value of the original work. That's
Yes,
also
it
a
could.
factor.
Yeah.
Yeah.
Yeah, or like, let's say, you know, and if you think about it in like really, I don't know, kind of silly, you know, but an example could be like, oh, well, I don't have to go buy the
Right.
poster, I can just
Exactly.
cut out this page.
Yeah, which is
Yeah.
what I ran into where
Yeah.
it was this very careful, like, you know, wording about how the works are actually, you know, 7 feet by 12 feet, so reproducing it at 5 by 7 inches was in no way
Yes,
competing
yes,
with the original.
yeah. And it gets hard because so much stuff has become licensed.
Yeah.
You know, there are such big licensing markets for all kinds of uses that people make. So obviously museums sell postcards size stuff of, you know, every famous painting. And so they could say, yeah, it's not supplanting the market for that big painting, but it is for our derivative market of postcards that we sell.
Mhm,
You know, and so, you know, when you get into a world where every reproduction or every kind of work could potentially be derivative of the original
Yeah.
and something that the copyright holder pretends they control,
mhm.
then, you know, of course everything has to be licensed. What wouldn't be licensed?
Right.
Did you have a question?
Well, I do, but I can.
Oh, sorry.
No, maybe you'll answer it I have a specific question.
Go ahead.
Well, so I've been writing about a particular artist a lot, and will go unnamed. And I got permission from his studio to use photos that I and my partner had taken in a couple of different venues, but I'm continuing to do this. So which was great because he's represented by our ARS, and I know that they can be really difficult or expensive. Can I kind of rely on that permission for future projects, or at a certain point does it become problematic? Do I need to keep re-asking them? And also, does it change dependent on whether it's used, for instance, in an online publication or a printed book or a journal or any?
So it totally depends on
And
what
color
they gave you
versus
permission
black
for.
and white.
So this is where the permission thing is very
Yeah.
complicated, right? So you got permission for a specific instance, and they are probably thinking, we gave you this. They are going to automatically say, whatever the narrowest thing is, they're going to want it interpreted that way. And you're going to say, no, I mean, I got permission, so I can do it. Right?
Well, I kind of framed it a little more broadly, and they gave me
But so we can't give you specific.
Sorry, no, I realize
so
that.
I'm just
yeah.
sort of like, in terms of how to think about this
Okay.
question, in terms of your risk analysis, right? Because this is what this is,
Right.
right? Is sort of like how much risk are you willing to take on with respect to potentially pushing the boundaries of the scope of whatever permission they may have already given you, right?
It depends if it's in writing, like these kinds of things. I mean, in general, you would want it to be in writing to the extent that you're, want to go ahead, and hold them to that. But obviously, if it's in writing, then it's clear, or maybe, what I mean. What you are agreeing to is also clear. Lots. I think that's an important piece if you're relying on the fact that they gave you permission. But yeah, it obviously depends on the scope of the license. So if they say,
So we can't really answer that.
Just generally speaking, from my perspective, the more specific the request is, the better for you. If you have an email from somebody who says, I give you permission to use this image in perpetuity for any purposes ever, no matter what, that's a different question. The more specific it is, I mean, it really has to be spelled out. Even if you have a kind of vague permission, a publisher might require you to go back and get it specified again. If it's
Now the
for
question,
more use
the other question that you might be sort of in the back of your mind thinking is like, well, if I go beyond that, could that be fair use? And the answer is yes. So just because they haven't given you specific express permission to do this extra thing over here, doesn't mean it is illegal to do it. It just means you don't have permission. Yeah. That doesn't mean they might not get mad at you, try to sue you, right? Come down on you in some way, right? And then that's the risk analysis, right? So it may be completely and totally fair use for you to do what you want to do. And, your lawyer might tell you that. Or that there's a very good chance, you have a very good chance of winning if it ever went to court. But that doesn't stop the back and forth of the sort of like, negotiation table and the fact that they are bigger than you.
So I have a follow-up, which is not related to me, but related to something you said about that there are no cases. So why isn't Stanford, for instance, seeking out a case to really pursue and create case law that defines fair use for scholarly work?
For scholarly work. I mean, we did. One of the very, very first cases that the Fair Use Project did was on behalf of Carol Schloss, and this was not an imagery case, but she had the James Joyce estate, which was notoriously just fanatics. Like the grandson, James Joyce's grandson, is a nut. He's just crazy. And he says no to everything. I mean, he was denying her permission to quote medical records. He doesn't know how to copyright medical records. So like her publisher was like, no, take it out of your book because we're not doing it. He's not going to give you permission, and we don't want to get sued. And then her book was criticized for not being well supported. It was just like, I have support, I just can't quote. So anyway, she ended up suing him for a what's called a declaratory judgment that her stuff was fair use, and it wasn't an actual decision, it settled. But they did agree, whatever. It worked out very much in her favor. She was able to recover attorney's fees from them, and so it is kind of that, having people who are willing to stand up for it, having people who are willing to fight. But you know what, like I say this all the time, like as somebody who has done impact litigation, it isn't so easy as like, well, we're just going to have a case about that, because you need two people who are crazy enough to want to litigate. So you got to have somebody on one side who's strong enough and believes in the principle and is willing to risk it all, and maybe at the end of the day be no better off, much worse off than they were in the beginning. Plus the other side has to be like, yep, we're going to fight about this, because you know what? Like I said earlier, it's a risk for them too. So if
they don't want
bad case law. So if they want the grayness, so that you can personally come to them and say, give me, I have to pay commission, whatever.
Culture of fear.
Right. Exactly. So another case that we did. That's not scholarship exactly, but the Harry Potter case. Where it was a Harry Potter encyclopedia of all things. Harry Potter, and he was sued. There, that was classic. I think example. Our client was a little bit like, we were like, I can't believe this guy he didn't care. Like, he was the publisher and he was risk adverse to like a degree that I found shocking, because J.K. Rowling and Warner Brothers sued him for copyright infringement for wanting to publish this encyclopedia, and he was willing to fight about it. He didn't have a lot of money, he didn't, whatever. So there's another case where it's like, really, you guys want to fight about this? Because now we're going to have a case, and have a decision that says, these kinds of encyclopedias are not a derivative work that you control. Whereas their perspective was, if you're making something and it's called Harry Potter or anything, you have to come to us first. And he ultimately, in that case, the court said that this particular manuscript wasn't a fair use just because it took too much of her original language and stuff. But they were able to, edit the manuscript and get to an agreement where they did publish the manuscript, published it as a book. And so that versus what the original position was, you are not allowed to do this. This is mine. I'm going to make an encyclopedia. You can't. Okay, you made your encyclopedia. You can go do it. And within certain boundaries, that I think ultimately is a bit of a victory, even if the original thing wasn't straight up fair use. So there is the risk for them. They don't necessarily want. So it isn't always so easy as get somebody who's doing it and willing to fight about it, because it takes two to tango.
I just will say briefly that, because there's filmmakers in the room as well as people who are writing that. Like you said, the people in film have really mounted more cases and have had more success truly articulating what their use policy is.
Yes. And
I learned this recently at the College Art Association conference, who I think you might know of their effect. Yes, exactly, that fair use publication, which is just actually, for the camera, I'll try to clean up my language. It just kind of lays out the facts for visual people using, like us, images in scholarship. And what it says is, we're in a mess. But that's very cleaned up language, because we're on tape. And so what College Art Association 1 is going to do is, having had these two scholars, legal scholars, Peter Yazzie and Patricia Alferhide, who've written on this and have collected kind of facts of what the ground situation is, now there's a second and third phase. They're going to go to
best practices.
Exactly.
What this is.
Exactly. So going to stakeholders, interviewing them, and then the subsequent and final phase, which will be the last one in about 18 months, 2 years, is to publish a report that says offers best practices. So for all of us in this room, we might have something that will be a stick to beat back.
I just want to insert that this document is free, downloadable on the College Art Association website, as is a YouTube of the panel discussion.
So from this College Art Association website, there has been, there was recently a fair use copyright discussion as part of their intellectual property standing committee's agenda. So the other thing I'll just say briefly is there's a scholar of visual resources named Christine Sunt, S-U-N-D-T, who is the head visual resources at the University of Oregon and publishes issues around visual resource collection. And she's a rather radical thinker who said from the beginning that our culture of permissions in art history and visual cultural studies is itself backwards thinking.
Yes.
There is nothing to ask, and I think you alluded to this at the beginning, there's nothing to ask permission for.
Yeah.
But we have been culturally trained
Right.
differently in our institutions to believe in certain kinds of forms of ownership,
Yes.
especially when money is changing
Yeah.
hands.
Yep.
But most legal scholars, as you've said already, would say, there is nothing for anyone to give you permission to do or to not do. And the fact that we ask for it is the first problem. So,
Right.
so
it's-
Stunt on her website goes off on this at darkwing.uoregon.edu and search her last name Stunt.
That's great.
It's part of our sort of courtier practice as art historians and
Yeah.
visual
Right.
cultural studies scholars, where we disempower
Right.
ourselves around these.
Yeah.
Well, and as Julie said earlier, so fair use is a muscle you have to exercise, right? It's if you're not using it, you're gonna lose it, right? So there isn't a culture of fair use. There is a culture of fair use in documentary filmmaking, in news reporting, right? The Daily Show does not license all of those clips that it shows, right? The Fox News is not going around asking permission, can I show, hey CNN, can I show this, political speech? They just show it, and then they comment on it. That's news reporting, man. Like, that's a culture where fair use is being exercised on a daily basis in a robust way, right? There is no reason why visual scholars should be treated any differently by the law, and in fact probably wouldn't be if it ever got to court. But so one of the exciting developments, and you already know then, is this development of best practices guides. So fair use can feel very fuzzy on the sort of in the outer areas, but there are things that are core, that are clear in the law about what you can do that is definitely fair use. And that is what these best practices guides are trying to do, to say, let's make concrete. Let's say, here are the specific things that we as documentary filmmakers, as media literacy educators, as poets, in our community, here are the things we all agree. There is no controversy here. This is fair use, and we're gonna do it. And nobody has been sued for doing the things in any of these best practices guides. Okay, so this is now a culture of communities coming together and saying, here are the ways that we think it's okay. And these are not super conservative documents, but they're not saying we're just going to take whatever we want either, right? They're not saying we can do anything. They have reasonable, balances, checks and balances in there.
One of the things that's great about these, particularly for documentary filmmakers, is that they are built they're built on the community practices, essentially. For documentary filmmakers, like you said, a lot of those were things have been litigated, and so there is case law that helps, define these areas before the guides came out. But in other areas where it isn't, even where it isn't necessarily closely litigated, or there isn't, exact precedent, because it's so fair use is so fact specific, you think like, oh, we need an exact case where this already happened so I can do it again. Not necessarily true, like the online video stuff, like that's all very new, kind of uses that people are making, and the things that people are able to do, poetry.
I just had I have a few questions actually, because I'm in this, talking about case law. I'm in a process of avoiding litigation at the moment, hopefully. But I have a couple of questions for you. And I guess the first one is about this idea of if you ask and are denied, you can still go for fair use.
You can.
Right? That's
You
the
absolutely
case.
can.
Because that's like,
Yes.
I mean, I have the citation here, but there's case law
Yes.
around that, right? So,
Yes.
From the U.S. Supreme Court has said,
right.
Yes.
it does, even if you don't have to ask for permission, but even if you do and you are denied permission, that does not
It's fine.
foreclose.
Right, because it
Your
says
ability-
the offer may simply have been made in good faith effort to avoid litigation.
Yeah, exactly.
Right, so,
Yes.
all right, so that's question number one. Question number two is, I should say, like, I'm in this position right now. I spoke with one of you on the phone, Julie. Hi.
Yeah.
Hi, Joanna. About this, where I asked for permission and the state said no, and I published anyway. So that's where I'm at now.
Okay.
And, have the insurance policy and the $4,000 letter from a lawyer and all this stuff. And I'm curious because recently the estate with which I am feuding just filed a lawsuit yesterday against Christie's. And in their lawsuit, I can't find the actual federal court papers. I've tried to find the actual filing, and I can't have access, I guess, I don't know. But apparently in that lawsuit, they're alleging that it is copyright infringement, that Christie's is publishing this catalog of works at auction. There's a lot of 40 objects, and they publish this catalog along with the objects, and they asked for permission to publish the catalog, and the estate said no. And they put on the back of the catalog, copyright, the estate of Jean-Michel Basquiat. And there's some confusion there for me because I can't see the actual filing. If their complaint is against the fact that they didn't grant permission, right? Because in one sort of news article it says that the catalog contains a copyright notice referencing the estate, but the estate claims the notice is false because they denied Christie's request for permission to reproduce.
So it's you're saying, is it a question that they attributed, basically you put the copyright
is it an
notice to
attribution
attribute,
question?
and then they're getting sued because the attribution makes people think that they gave them permission.
Right, they're saying, well,
Yeah,
they're
no,
also under this
it's
thing of the attribution, the copyright notice makes it seem as if the state signs off that these are all legitimate works by the artist, but they are contending that some of the works are fake.
I see.
Right? So it's kind of like a reproduction issue, but also...
This is just, I don't know about the specifics, but in a broader sense about attribution, one of the things that, I think people struggle with a little bit is so what do I do if you're relying on fair use and the principles, and even in all of these best practices guides will say attribute, people want to be celebrated, but you don't want to imply that you have permission.
Right.
So, for filmmakers, it's not in the special thing, it's not like thanks or credits or whatever, but if it lists, it's I don't know what the specific language is, but you don't say, used with permission and then list everything, including things that were not, obviously. And you don't, say thanks to the estate for this when they didn't give you permission. You just list it in a way, in a generic way. That'll be interesting. If that is, press reports are very notoriously bad for understanding what a lawsuit is about. So, but if that issue is actually being litigated in that case, that might be really interesting. Just the fact that, I don't know what there's no legal obligation to attribute. So I don't, other than a claim of fraud or misrepresentation, it's not a copyright claim.
Yeah, because I was always told by several lawyers that if you list, as I do in my book, copyright the estate of Jean-Michel Basquiat, that you are not implying permission. You're implying that there's copyright, and fair use is an exception to your need to request permission. And I think in this case, one of the news reports said that the Christie's catalog wrote copyright the estate of Jean-Michel Basquiat / ADAGP ARS, and I think it's that. Little
it's
part
just like
that
when
implies
Getty,
permission.
If Getty
not
puts their tag onto a photographer's thing and it's not actually Getty's, they can get, they can have problems for doing that. It's attributing it to their, as if they
just
own
that little
it.
piece on the end that's the problem. But sorry, I have a lot of questions.
Oh, no, go
and
for
I'm
it.
not paying $400 an hour. The other thing I had a question about was the same case. They're claiming that they were denied permission. The Christie's was denied permission. They did it anyway, and this is kind of a big part of their complaint. And I'm wondering, from a legal standpoint, because I'm not a lawyer, it seems obvious that if I were a lawyer hired by the estate, that I would say, well, actually, no, there's a Supreme Court case that says denial of permission doesn't actually give you a right.
But it depends on whether it's a copyright claim or a representation claim.
Okay.
So we don't know.
All right.
And it also, it doesn't stop people from. There are lots of things in cases.
You can still do it anyway.
Well, it doesn't stop them from coloring the fact. If the fact is, you came to me and you asked me for permission and I said no and you did it anyway, and I'm just laying out those facts as part of the story, and that's true, there's no reason for them not to, even if as a matter of law, a court is going to say, okay, yeah, that happened, but we don't, we've been instructed by the Supreme Court that doesn't matter. It's not going to stop them from asserting that it did, or trying to color the case as, you know, just like with lots of cases where the plaintiff will say, you are acting in bad faith because you never even asked me, you just went ahead and did it, and there's case law that says that doesn't matter, you don't have to ask for permission, you don't have to do that first, you can go ahead and rely on your fair use, you know, rights before doing that. It just, it's just a way of coloring the facts, and sometimes that's what, you know, honestly, even if the law says it shouldn't matter, sometimes judges, you know, are like, well, yeah, this person doesn't look so great, or it colors their kind of gut reaction to the case, and that's why they want to do it. That's
so
why
they're
they
allowed to kind of do what they want on the filing of the complaint, but in the actual
She was her, they have to tell the
case, that's when
right,
that argument would happen.
Yeah.
Is
So
in the actual.
whether it's a, you know, we can assert whatever facts that are true, regardless of how relevant they might be in the ultimate analysis.
Okay.
Right. They may or may not be stating a claim.
Right.
Right? They might just be saying,
Yeah.
here's what happened, Judge, I don't like it.
Okay, yeah, that was what's confusing me.
Yes.
I was like, well, obviously this is wrong. Okay,
Right.
all right,
Yeah.
cool, thank you.
I have one question about Jordana's case, but which is,
Don't we all?
wasn't that also a lot about the authentication, in which case, which is completely separate
From copyright.
Yeah.
And do you have to list that a work is copyrighted? Isn't that implicit? I was always told that actually you don't even need, on a printed material, you don't even need the copyright because if you can prove that you created it.
It's true. That you own, as soon as you write down or fix whatever your work is, it's copyright protected. You don't have to have, it used to be the case that you had to register and you also had to use the symbol, you know, to indicate that it was a copyrighted work in order to preserve your protection, but that is no longer required by the law. So no, you don't have to.
But if we're using the word...
If you're using it, it can become tricky only, I think, because there are other parts of the law that, you know, you're not allowed to remove copyright information from a work, and so I've seen a case litigated where they used images from a magazine and they cut the gutter. They cut the copyright notice off the bottom of it and reproduced it on their website, and that was like a separate violation, which for all kinds of other reasons I think is not a correct interpretation of that law. But there's that part too, so it can get, you know, to the extent that you're using, you know, if you're like taking it from someplace and it has copyright information in it, you don't want to remove it because then you could be in violation of removing copyright, you know, information.
Right, so there's a difference between I created a thing and I am saying I own the copyright in this and I need to put a notice on it to claim my copyright. You do not have to do that. Okay, but when you are using it for scholarly purposes and things like that, again, there's no law that says you have to, but again, sort of norms of the culture is that you would attribute and say, this is, you know, a work that I am commenting on and it is by somebody who is not me, and this is who it is, right? So,
yeah.
Well, I don't have a problem with the attribution, but literally the copyright notice.
Yeah, I would say the only law that may apply in that situation is the removal of something.
Okay.
If it's metadata, or it could be even physical, like literally the gutter of a photograph or whatever. Those kinds of things you want to look at.
So do you think, like, in that case, like, if there's a caption and it says, just a weird example, Jean-Michel Basquiat, right? Untitled 1987. Should I not put copyright the estate of Jean-Michel Basquiat?
Well, we can't give you a specific.
Well, no, but I mean, but there's no reason to do that, is what you're saying. It's not necessary to actually, if you say it's the author.
Yeah, the law doesn't. Yeah, exactly. The law doesn't. There isn't a specific, like, this is how you have to attribute and this is how you do it. You know what I mean? So obviously, you know, to the extent that attribution is something that everybody, in general, I think most people agree, like, it's a good thing because you don't want to be passing it off, obviously, as your own. It's the same as footnoting for an article or what, you know what I mean, like that kind of sense. But whether or not in the specific instance we could say. So.
Just write this thing down quickly. So it's copyright and art issues is the probably useful search term for someone who's in visual resources and how to use publication, how to use...
which is all on...
no, this is not CAA's. This is SUN's.
Yeah, it's...
And it's Her name is Christine
Yeah.
L.
It's,
Sunt.
It's darkwing.uoregon.edu.
Yeah, so, and then separate from that, if you go to CAA, College Art Association, not Casino Gamblers Association, which comes up. Sometimes CA.org, you'll see that there's a video of this copyright discussion at the recent conference.
I would also like to plug Susan Bielstein, who's an editor for art and culture publications at the University of Chicago, who's put together.
What's her last name spelled like again?
Bielstein, Bielstein.
And she's Christine with a C?
No, Susan.
Susan, sorry.
And she's Permissions, a Survival Guide. We like to talk about art as intellectual property. It's really good for, it's a really good handbook for our kind of stuff. And she's sort of been through it, and there's a lot of examples just in the book of what she went through, or didn't go through, to include images, some of which are thumbnails.
Right, right.
And what that whole risk, the risk equations involved in how far you go to track down, procure what kinds of, how many layers of permission.
Yeah, and I think one of the things, so like we said at the beginning, one of the points of what we want to do, and I think, saying to group artists or users or communities to say, like, exercise your right now, part of that is understanding what they are and, trying to get a good sense of that and giving you kind of the tools or certain information that can help. And I think, just getting back to these best practices guides.
Yeah.
These are.
So there are. We could just go through what some quickly at the end here. Here are some high-level things that cut across all of these best practices guides that all of these communities feel like this is cool for us to do, right? So analysis, criticism, commentary on copyrighted material. That is classic. What you guys are doing, right? It's classic. I am writing my thesis on Basquiat, and I need to show his work so that I can make a commentary on them. That's pretty classic thing. People agree. This is, it's in the preamble. Scholarship, research, those are things that are generally considered to be within fair use. And other communities are claiming, whether it's media literacy, educators, whether it's documentary filmmakers, they're all saying this is pretty clearly fair use. Now, again, they're doing it and not getting sued so far, so cool. Another sort of way in which this is similar but different. So it's using a copyrighted work to make a point as opposed to you're directly commenting on it, right? So as an example of, say, how race is portrayed in the media over time, I'm going to use these 5 images to make that point, to tell that story, or I'm going to show these clips from these different television shows to talk about a separate point, right? So this is another sort of classic way in which communities are using copyrighted works and claiming that to be fair use. This is pretty, again, sort of core within what courts have said forever. This is pretty clearly fair use. Again, sort of using the copyrighted content either as part of a historical sequence or to put it in historical context. We saw that in the Grateful Dead case. There's another case about the musical The Jersey Boys that has to do with using a 7-second clip from the Ed Sullivan Show within the context of this musical. And the court there said, this is very obvious, clear, fair use. What you're doing here is you're using this clip to put the narrative in historical context. Perfectly legitimate thing to be able to do. Again, it's a tiny clip within the context of a broader, so all of these are, have to be thought about within the context of all of the factors, right? You don't want to be taking too much. You want to make sure you're giving a new message and meaning. You want to think about the market harm that you might be doing to the copyright holder. But generally speaking, things within these categories are going to be favored by fair use. We're not always going to win, but these are favorite categories. And then finally, using copyrighted materials to start a conversation or spark a public debate. This is pretty, I think, like, news reporting does this all the time. Bloggers do. I mean, this is, you know, documentary filmmakers. It's something like you want to throw up an image in a context like this and say, hey, let's have a conversation about this image. You know, within the context of this room, I don't think anybody would argue that that's fair use. Put it up online, and then people are like, oh, is that still fair use? I mean, yeah, it is. You might have to fight about it, right? There's no case that says that, but
right.
You know,
There are a lot of the principles that come out of the cases that have been litigated make it really clear, and you can, you know, line up those arguments.
Do you see any difference? Like, I'm wondering, like, if I were sued, is there a better court to be sued in, and do I have a choice? Like,
I
it's
think,
California versus New York. Like, what's the?
You know, the law that's developing in the Second Circuit, which is in New York, is much more developed. It's much more clear. They're like, you know, that's where you get the Second Circuit is where the Richard Prince case comes out of, where you know, a couple of the cases that Brianna was going to talk about that we skipped, but like Google Books. I mean, you want to talk about something where they're just, you know, they have scanned whole copies of millions of books to create a different tool. So, you know, and those are being upheld as like, yep, that's, you know, transformative, that's different, you know, and those are really solid. Frankly, I think the California courts, particularly the Southern California courts, are very close to the content industry. They have a different, you know, like when you think about who the constituents are, not that the judges are beholden to those constituents, but those are the kind of cases they see, the people who come in there, that's, you know, they're more leaning on that side of protecting the copyright kind of, you know, entrenched view. Licensing culture is a huge part of Hollywood.
Yeah.
So they have much more of that sense of you should just get a license. But that's not to say, I mean, I've litigated cases in New York where they lost, where it's like, this is garbage, you know, it does, you know, like the district court, you know, there's lots of judges there, so it depends, but, you know, as far as the law that has developed, I think it's better in the Second Circuit.
Okay, so the reason this door keeps opening is because there's an all chairs meeting in here at 12. We have, like, always, unlike Cal, no 10-minute.
Oh, you don't have to